This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why liars must always lose and why presenting a false medical history during a no-fault insurance claim defeats that claim in its entirety, and why a lie after a bicycle accident to claim no-fault benefits failed. This case arose out of an accident that occurred in 2019. The plaintiff was hit by a car at around 8:15 p.m. while riding a bicycle in Flint, Michigan. Plaintiff sustained serious injuries, including multiple broken bones and lacerations, blunt force trauma to the chest and abdomen, and a traumatic brain injury. However, he submitted a claim with false representations about his past medical history, and his suit was dismissed. Ronnie Fields appealed the trial court's order granting summary disposition to the defendant, Nationwide Mutual Fire Insurance Company. In Ronnie Fields and Anderson Medical Supplies versus National General Insurance Company and others, a decision of the Michigan Court of Appeals in August 17, 2023, the Court of Appeals gave effect to the allegations of fraud. In relation to the accident, plaintiff submitted 2 applications for personal protection insurance, PIP benefits, through the Michigan Automobile Insurance Placement Facility, the MAIPF. The application stated that plaintiff did not have any of the same injuries prior to the accident, that he had no pre-existing medical conditions, and that he had not applied for Social Security benefits before or after the accident. However, his applications noted that plaintiff was eligible for Social Security benefits contrary to the information in his first application. Each of the applications contained the standard fraud warning. Plaintiff sued in February 2020. The MAIPF was required to assign his claim to an insurer. The MAIPF eventually assigned his claim to Nationwide, and Nationwide was substituted as a defendant. Nationwide ultimately filed a motion for summary disposition and alleged that the plaintiff committed fraud by submitting false information in support of his claim for PIP benefits, and that he was, therefore, ineligible to receive benefits. Nationwide also alleged that plaintiff failed to disclose that he had eye surgery prior to the accident, that he is legally blind. Nationwide claimed that plaintiff violated the statute by knowingly submitting false statements in support of his claim for benefits. The trial court entered an order granting Nationwide's motion for summary judgment. In Michigan, a person commits a fraudulent insurance act when 1. The person presents or causes to be presented an oral or written statement. 2. The statement is part of or in support of a claim for no-fault benefits. And 3. The claim for benefits was submitted to the MAIPF. Further, 4. The person must have known that the statement contained false information. And 5. The statement concerned a fact or thing material to the claim. Finding no dispute that the 2 applications for benefits erroneously indicated that plaintiff had no pre-existing medical conditions and had not sustained any prior injuries that might be relevant to his claim for benefits, plaintiff's disposition testimony and medical records ultimately revealed that between 2012 and 2019, he was treated for complications arising from a dog bite and for injuries sustained after someone struck him with a baseball bat, including a leg fracture. Additionally, it was undisputed that the plaintiff was legally blind, which was not disclosed on either of the 2 applications he submitted. The October 4, 2019 application also noted that plaintiff was not eligible for Social Security benefits, which was ultimately determined to be a false statement. In analyzing the issues, the court noted that the plaintiff's medical records could be considered as evidence of fraud. Even though the medical records were obtained by Nationwide during discovery, the information contained in them concerned incidents that occurred well before plaintiff applied for PIP benefits through the MAIPF. Although such evidence would not directly show that plaintiff engaged in fraud, the medical records pertain to incidents that happened well before litigation commenced. Consequently, they were properly considered by the trial court as documentary evidence in support of Nationwide's fraud assertion. Plaintiff signed the applications, suggesting that they must be considered his own. He argued that it is unclear whether he knew what he was signing, as he was legally blind at the time and would have needed someone to read the document for him. Plaintiff's medical records were not improperly considered as evidence of fraud, and moreover, since plaintiff signed the applications, particularly the November 4, 2019 application, and has provided no evidentiary proof to support the argument that he lacked the capacity to do so, that he did so by mistake, or that he was coerced or defrauded in this case, the trial court's ruling was affirmed. In my opinion, even no-fault insurance statutes remove the right to benefits if the person seeking the benefit commits fraud in seeking those benefits. There's no question that the plaintiff filed 2 applications for benefits that contained false statements. As a result, even though he was seriously injured, his fraudulent statements defeated his claim, proving that liars in Michigan will never profit from the no-fault system. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. It is also subject to being subscribed to, also for free, and you will receive notice of at least 5, sometimes 6 blog postings a week. You can also subscribe to the videos on YouTube and rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on Rumble. And if you wish to consider further insurance law, insurance coverage, insurance fraud, and insurance claims information for a very small fee, you can subscribe to my Substack publications or my locals community. Thank you for your attention.